Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes. Hi everyone, my name is Sherine Abdi and I'm with Angela Princewill, and in today's episode we're going to talk about excluded property under the Family Law Act.
Yeah, so hi, I'm Angela, and if you're listening to this podcast, chances are you already have an idea of property division, equalization, to be specific for people that are married. And if you don't, you probably want to listen to one of our earlier podcasts where we really talk a lot about how net family properties are equalized. But in the context of that, you will have to deal with properties that are excluded. And that's something that comes to people's minds a lot. Like, I understand I have to equalize my property with my ex, but can I take XYZ out? So I'm going to just go through a quick list of what is, considered or what are property that can be excluded based on what the Family Law Act says. So the first is property other than a matrimonial home that was acquired by gift or inheritance from a third person after the date of marriage. So any property that was acquired by gift or inheritance from a third person after the date of marriage, except a matrimonial home. Income from such property if the donor or testator has expressly stated that the income should be excluded. So I wouldn't give descriptions. Sherine and I could have gone more in depth later, starting from the top. So let me just reel off the list. So number 3, damages or right to damages for personal injuries, nervous shock, mental distress, or loss of guidance, care, and companionship, or part of a settlement that represents those damages. Proof or a right to proceeds of a policy of life insurance as defined under the Insurance Act that are payable on the death of a person who was insured. Property other than a matrimonial home into which property referred to in paragraphs 1 to 4 can be traced, and property that the spouses have agreed by a domestic contract is not to be included in the spouse's net family property, and unadjusted pensionable earnings under the Canada Pension Act. So that's the list. And sure, let's start from the top. So this is usually the biggest one, actually. Property other than a matrimonial home that was acquired by gift or inheritance.
Yes, I think it's the most popular one. Most common exclusion as well.
Mm-hmm.
But essentially, any gift or an inheritance received after the date of marriage and gifted to one spouse.
I'm glad you're clarifying that. It has to be after the date of marriage.
And it's gifted to one spouse is property that would fall under the parameters of being excluded. So we would include the asset, but then we would essentially exclude it. So, if for
the net effect is the same thing, right?
Yes, the net effect is the same, but when we say we're excluding it, it doesn't mean we don't include it at all. It's just from the calculation, we will adjust it to basically be the net effect.
No, I'm glad you say that, because some people would just not include it in their financial statement, and it's wrong because it looks like you're not disclosing.
Yeah.
You disclose it, but you don't share it. If that makes sense. And I think with a lot of people, having older parents and things like that, so they pass and they leave the home to you and things like that, or they leave cash. It's nice to know that, you can get to keep that for yourself. However,
yes.
If your grandma leaves you a house and that home becomes your matrimonial home, it cannot be excluded.
Yeah.
If they leave you cash that you use in renovating the kitchen and bathroom of the matrimonial home, that also cannot be excluded.
So just think of if you want something to be, or really an inheritance to be excluded or a gift, you want to keep it separate from, first of all, the matrimonial home.
That's the biggest one, from the matrimonial home.
It loses that characterization, but ultimately you want to keep it separate and you want to be entitled to trace it. So if you received $50,000 of which you spent maybe $20,000 on a vehicle, So long as we can trace that from the original, we could exclude it.
Yeah, exactly. That's a good point. So the second kind of property that can be excluded is income from property that we've just talked about. And this is an interesting one because say, you're left with a home and, again, grandma gives you a home and you decide to put tenants in it. You need to recognize that while we may be able to exclude that home, the value of the home, if there's a tenant in that home that's paying you rent and that has accrued in some bank account or whatever, except grandma specifically said, income from the inheritance cannot, is not to be shared with your spouse or something, except that's specifically clarified, then you will have to share that.
Yeah.
I think another example, okay,
for support purposes. So like if you were, earning $1,500 in rental income, that's $1,500 for income purposes. And you would share. Well,
you would share that.
Would share that kind of.
But if it's sitting in the bank, then that's a different ball game. Another example is even with I was thinking of in terms of even like shares, for example. So that's a very common one. So you sell this home, you get $500,000, you invest it in the stock market, maybe you buy some cryptocurrency, everything's going great, and now we're doing in the equalization process. $500,000 is now worth $700,000 of cryptocurrency. There's an argument to be made that $200,000 is not excluded property because it's income that was generated on the $500,000. You will get your $500,000 excluded, but if the will or whatever instrument that gave you that inheritance made it clear, it's usually in a will, that the income is to be used by you only and not to be included as part of any net family property calculations, then you get to keep it free and clear. And I mean, we have people at our offices, lawyers at our offices that draft wills and things like that. And that's part of, what people get advised, especially for older, persons that are doing their wills, to make it clear that, okay, if you're gifting something, do you want to exclude the income and things like that?
Yeah, so if you have, an inheritance coming to you and you're in the process of separation, or maybe not yet separated, you definitely want to take care of that issue. And maybe if you have a good relationship, if you know that property is coming to you, or a gift of some sort, that you want any income that can be generated from that to be also excluded.
Excellent. Yeah. And the other is damages, or a right to damages for personal injury. I mean, I guess that's pretty straightforward as it gets. If you were injured in an accident, you get a settlement. It's your property to keep, and you don't get to equalize that with the other. But it gets interesting when you get those settlements, because someone, I know this has happened with you recently, Sherine, and a client just tells you, well, I got $1 million in settlement, but
not all of the portion is excluded, because part of the settlement, depending on the settlement that you have, for example, this settlement was structured on several different bases of entitlement, but essentially part of that settlement was for past income loss, and that's something that is not excluded. So when you have structured settlements, usually they'll outline what the different heads of damages were for, and some of that may not be excluded. So we say that with the caveat that for most part, you can exclude court settlements and damage claims, with the exceptions of certain things that may apply.
So if you're the person that's disagreeing with an exclusion, I mean, just request disclosure, get the statements, the file from the real estate from the personal injury lawyer, and
company,
yes,
whatever you need,
so that you can see what portion of that it goes to income, or what anything else besides damages, right? So, okay, and then the proceeds, or a right to proceeds of a policy of life insurance is also excluded. So yeah, this is interesting, I guess. I mean, a lot of people have life insurance just for to make sure they can take care of dependents and things like that. And for some people, life insurance is also part of estate planning. It's a way to leave an inheritance for children as well. So under the act. I mean, I guess if you got a life insurance payout, you can exclude that amount. Again, subject to everything, Sherine and I had said earlier about making sure that, it doesn't go into the matrimonial home, making sure that
it can be traced.
Yeah. So the other head is property other than a matrimonial home into which properties referred to in one of four can be traced. So again, repeating what we've said, if you have, if you got an inheritance, income from that inheritance, damages as a result of personal injuries, or you got a life insurance proceeds, if any of that money goes into a matrimonial home,
or joint bank accounts.
Yes, I was going to come to that. Yeah, but the act makes it very clear that if it goes into a matrimonial home, then you can't. It loses exclusionary value. Otherwise, so long as it can be traced, you would get that exclusion. I'm going to park the joint because I think that's a very that's a conversation that I want to unpack. Yeah. So, but I just want to run through this list. So, number 6 is property that the spouses have agreed by domestic contract is not to be included in the spouse's net family property. I like to think of myself as the poster child for marriage contracts or cohabitation agreements. Usually, cohabitation agreements would become a marriage contract if you get married, so you don't have to do another contract if everything still stays the same. But see, this makes it clear. If in your contract you say we're not going to include, my your whatever pension. Collection, or through your pensions, my collectibles, my whatever the case may be,
RSP or whatever the case may be.
And in this case, if you notice, it's not qualified by that matrimonial home loss of exclusionary property rule. If you have a domestic contract, you can choose to exclude the matrimonial home from your net family properties and you will be fine. Yeah. That's honestly the safest thing to do. Right? So in the marriage contract as well, you can also stipulate that income from any property that you have should be excluded as well. So that way, if grandma is now too old to update her will or whatever, that's a way to make sure that, whatever gains you make in the future is protected. So yeah.
And if you don't have a marriage contract by the time that you do get an inheritance, but you still wish to protect it, or property or any property that you wish to exclude, you could still enter into a new marriage contract in any point of your marriage, which is also a common
misconception. Yes, people think that because they're married now, and I think it's because of the terminology that's used in the US, and that's what everyone knows. It's like a prenup, and it's almost like, okay, it's a prenup, so now that we're post, it doesn't apply to us anymore. But no, in Ontario, it's called a marriage contract. It can be entered into at any time, so long as you're not in the process of separating, then you can do that. So that's a very significant one to me, because it's one of the only sort of properties that you can have and put it, it's one of the only ways that you can put in whatever you like into the matrimonial home
to really deal with all of the properties you wish to exclude instead of individually.
Yeah, because think about it too from a practical perspective. The matrimonial home is where you live. Yeah. You want to be comfortable. God knows I always have a running list of renovations that I want to do. So now I run into this inheritance, and it would be very hard for me to resist the temptation of not putting a huge portion of it into all the projects that I always never seem to finish. Mm-hmm. So, and you want that comfort. It's my home. Comfort,
but you also want the benefit.
But then I want to be able to protect it, right? Yeah. So this is really, getting a marriage contract would be the best way to do that. And I know the terminology in the act is domestic contract, and that refers to cohabitation agreement and marriage contracts. And the last item listed is unadjusted pensionable earnings under the Canada Pension Plan. So this doesn't mean that you don't share your CPP. It just means that CPP is usually not shared as part of the equalization process. So that's why it's excluded. So your regular, for those that have pensions that either has, a defined benefit in the sense that it tells you exactly how much you would get a year after you retire, or for those that are even contributing to some kind of employer funded / supported pension program, when you go through a separation, we would have to include the values of those pensions into your net family property calculations in order to equalize it. But we don't put in the CPP, it's excluded. There's an separate application done to Service Canada to split your CPP pension credits later. This seems a good point to add that I see a lot of contracts where people say we shall not split our CPP.
Oh, yeah, you cannot apply to split.
And it's interesting to us because we're like, okay, change it, don't change it, but that clause is unenforceable. So just don't be that person that thinks, they've agreed to not split your CPP and then be shocked when your spouse actually splits it, because you can't, in Ontario, you cannot contract out of that provision. So if one party applies to split the CPP, it will be split. But again, it's a separate process. It's not done as part of calculating equalization. So very quickly, Sherine, I want to jump into sort of this tracing, because the whole essence of sort of excluded property is tracing. And that's all well and good when you bought yourself a vehicle or you put it into a sole investment.
Or where your inheritance is recent. You can easily trace something.
But for most people, they put it in a joint account.
Yes.
Of course they did. You're with the person. You're going to put it in a joint account, right? Well, I don't know. If you're not going to be happy giving the other person 50% of it, then maybe don't put it in a joint account. Because the fact that you put it in a joint account is prima facie seen as an intention to give to that person 50%. Now, it's a rebuttable presumption, but I just don't always like starting out with a presumption being already made against me.
It was the intention of you putting it in a joint account. It was the intention to share it, the intention to gift it. So you already have work to do. And
we know that presumption is not necessarily accurate. We have successfully argued against it for a client because a lot of couples that have been married for a long time only have a joint account.
If it's your only account, like what?
But the ideal thing is don't let it sit there for too long. Once it lands in there, move it out.
Yeah.
And what would happen, and the disadvantage with having it in a joint account for so long is even if we're able to rebut that presumption for you, we most likely would not be able to exclude everything. We would only be able to exclude what is left. So an example is if you inherited $100,000, you put it in a joint account, and somehow you're both living your life from that joint account, and things and now you guys have thousands of dollars in other respective accounts and all of that, but you only have $50,000 in the joint account. First, there's a presumption that half of that belongs to the other party. But let's say we do the hard work and we're able to actually make your case out for you. You're only going to be able to exclude $50,000, not the $100,000 that you received. So again, if the intention is not to give the other party half the funds, then just, even if it lands in the joint account at first, please move it out as quickly as possible. I don't like presumptions being made against me. I don't really like default presumptions of the law. That's why I like the idea of having a marriage contract. If I'm going to gift half my inheritance, I want to be able to do it on my own terms and not because I was obligated, legally to do that. But that's just me. So is there anything else you want to add?
I'll just conclude by saying if you are seeking an exclusion, the onus is on you to prove that exclusion. So you have to go beyond, provide the documentation. If there's a tracing involved, you have to trace the asset, and so that it doesn't lose its exclusionary nature, and so that you meet the parameters of excluded property. But make sure that you do know that you can't just plop it on there and say, well, it's an inheritance, it is what it is.
Or some people would say she knows my grandma gave me whatever. But the onus is not on her. She could just sit there and exactly.
She may just conveniently forget, and that's the sad truth is it happens all the time. So you definitely want to make sure you get the documentation, and things might be great now, but you never know down the line. If you really do want to exclude property, Keep it separate. Don't put it in the matrimonial home if that's not your intention. And yeah.
Okay, so that's it for excluded property. And until next time, it's bye for now.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.